This is an audio test. Can someone out there hear me?
Yes, it sounds good on my end.
Thank you.
Hey, good morning, everyone. Just wanted to do a quick video and audio test.
Good morning. The
Mic-
audio and video looks good.
Okay, great. Thank you.
Likewise, I assume you can hear me?
Yes, I can hear you. Thanks.
Okay, good. Jason, I understand you're on paternity leave. Congratulations.
Hey, Tom. Thank you.
Good morning. Can you all hear me?
Good morning. It sounds good.
Thanks.
All right, is everybody ready to go? And can everybody hear me?
Yes,
And Miss Kunkel, are you the one who's in charge?
Yes, good morning. I'm here.
Okay, and I take it you're ready to go as well.
I am. Thanks.
And it looks to me like we have counsel for all of the parties here. So, we are on the record in the Colorado Public Utilities Commission's proceeding number 23AL-0325G. My name is Connor Farley. I'm the administrative law judge assigned to this proceeding, and it is approximately 9 a.m. on November 20th, 2023, and this remote hearing is being webcast. This remote hearing was scheduled in decision number R23-0596-I, dated September 11th, 2023. The hearing was scheduled as a remote hearing in which the participants are participating from discrete remote locations, including myself. Decision number R23-0563-I included instructions for participating in this remote hearing by computer or telephone. I will take appearances, please, starting with public service.
Good morning, everyone, and good morning, Your Honor. My name is Tyler Mansholt, and I represent Public Service Company of Colorado. Thank you.
Thank you and welcome, Mr. Mansholt. I will go to staff next.
Yes, can everyone hear me okay?
I can.
Okay, great. Good morning. Michael Santisi, Senior Assistant Attorney General, appearing on behalf of staff.
Thank you and welcome.
Thank you.
Let's turn to UCA.
Good morning, Your Honor. This is Assistant Attorney General Patrick Wittersheim. On behalf of the Utility Consumer Advocate, I'm joined by my co-counsel, First Assistant Attorney General Tom Dixon.
Great, and thank you and welcome to you both. Okay, we are conducting this hearing utilizing electronic pre-filed exhibits as much as practicable. A spreadsheet has been prepared to navigate documents pre-filed in the Commission's administrative record. The spreadsheet has been marked as Hearing Exhibit 500, I believe. Is that correct, Ms. Kunkel?
Yes.
Okay. Hearing Exhibit 500 reflects the date of the latest filed version of each exhibit as it appears in the Commission's administrative record, a title reference for hearing exhibits that will be utilized during the hearing, and the titles of the hearing exhibit is reflected in the Commission's records. Any exhibit listed in the spreadsheet that is admitted into evidence will be admitted by administrative record based upon the existing files referenced in the Commission's files. As such, those portions of the administrative record would become part of the evidentiary record. The fact being administratively noticed is that the electronic pre-filed copy in the administrative record is the content of the otherwise admissible exhibit being admitted. Now, you were emailed the spreadsheet marked as Hearing Exhibit 500 on November 15th, I believe. I think you've had plenty of time to review it and suggest any changes to Hearing Exhibit 500. So a couple of questions. Does anybody have any proposed changes to Hearing Exhibit 500? Not hearing any. So is there any objection to the admission of Hearing Exhibit 500?
Your Honor, I'm sorry, I just lost internet temporarily, so I had to take my witness's seat. So this is Tyler Mansholt from Public Service Company. Sorry for this early snafu. I'm not sure what's going on, but a quick thing on Hearing Exhibit 500. The company has noticed that our advice letter itself, as well as the associated tariff change that comes with the advice letter, are not listed on Hearing Exhibit 500. We have those two documents right now in box.com, and they are marked as, for the advice letter, Hearing Exhibit 100, and for the tariff, it's marked as hearing exhibit 108. It would seem appropriate to enter those into the record as well, those into admission as well. And outside of those changes, the company would be fine with admitting to the record all of the exhibits listed in hearing exhibit 500.
Okay. So thank you for that, Mr. Manschultz. Ms. Kunkel, can you pull up and make available to the other parties hearing exhibits 100 and 108? And Mr. Manschultz, you've represented the hearing exhibit 100 as the advice letter filed at the outset of this proceeding. And that hearing exhibit 108 are the accompanying tariff sheets, including the changes, proposed changes to the tariff. Do I have that right, Mr. Manschultz?
You do, Your Honor.
Okay. So I'm going to give a moment to the other parties to review this. And ultimately, my question is whether anybody has an objection to the admission of hearing exhibit 100 and hearing exhibit 108. So, and when you are ready, Mr. Santisi and Mr. Wittershine, please let us know whether there is any objection.
No objection from UCA, Your Honor.
Thank you.
No objection from staff.
Okay, thank you for that. And thank you for that clarification, Mr. Manschultz. So let me come back around to hearing exhibit 500. Mr. Manschultz, I take it that's the only issue that you have with hearing exhibit 500. Is that fair?
That is fair, Your Honor.
So let me ask generally to all of the attorneys, is there any objection to the admission of hearing exhibit 500?
No objection for public service.
None from UCA, Your Honor.
No objection for staff.
Thank you. And I take it that that means, but I'll ask it, if there's any objection to the admission of any of the exhibits on the spreadsheet, which is hearing exhibit 500. And I'm not hearing any objections, so hearing exhibit 500 is admitted. Okay, so the hearing is scheduled for one day, and based on the cross-examination matrix that you submitted, it looks like maybe we only need this morning if things go efficiently. Does anybody disagree with that? Okay. So then the order of the witnesses will be as presented on the cross-examination matrix. As always, the order of examination of each witness will be an introduction direct, cross-examination, then I will be given the opportunity to ask questions if I have any, and then redirect after that. So I'm assuming nobody wants to make an opening statement. This is not a complex proceeding, so I don't think one's necessary, but I thought I'd give the opportunity. Does anybody want to make an opening statement? Okay, not hearing any, so are there, go ahead.
Right. One question. You admitted into evidence exhibit 500 and also talked about all the exhibits on there, whether there were any objections to that. I'm assuming all exhibits that were on exhibit 500 have been admitted into evidence.
That is correct.
Thank you.
You're welcome. So are there any other issues that anybody would like me to address before we dive into the evidence?
No, Your Honor. The only thing is that for a technological issue, I'll need to go back to another office real quick and restart Zoom, which I understand my internet is now working. So I'll probably need a minute or two to get my witness solo in this room here and me back online on a different room.
Okay. Well, why don't well, let me just ask whether anybody else has any other issues before we dive into this. Okay, I'm not hearing any. So why don't we do this, Mr. Manchell? Why don't we take a break for 5 minutes to let you do this? Hopefully that'll be sufficient. If it's not, just come back online on somebody's computer, and let us know what you need at that point.
I think
So,
it'll work, Your Honor, and apologies, but thank you so much.
yeah, you're welcome. And let me just apologize to all of you. I'm battling a little bit of a cold. Anyway, it's not going to interfere, but I sound a little bit different and I'd be maybe sniffling and stuff like that. So just bear with me. So with that, let's take a break. It's 9:10 until 9:15, and we'll be back on the record at 9:15. Thank you.
This is just another audio test. It looks to be that my system is working again. Thank you.
It sounds good on this end.
Okay, is everybody ready to go?
Yes.
Excellent. So we're back on the record in proceeding number 23AL-0325G. And Mr. Manchel, you can call your first witness.
Public service calls to the stand, Mr. Jason Piquet.
Thank you for that, and welcome, Mr. Piquet. Good to see you again.
You as well. Good morning.
Thank you. So please raise your hand and answer the following question. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Great, thank you. And Mr. Piquet, let me just ask, is there anybody in the room with you while you're going to be providing your testimony here today?
There's not.
Okay, if that changes, just let me know. And if anybody attempts to communicate with you other than through the record online here, while you're giving your testimony, please let me know that as well, okay?
Will do.
Great, thank you. So, Mr. Manchel, you may proceed.
Good morning, Mr. Piquet.
Good morning.
Please state and spell your name for the record.
My name is Jason Piquet. Last name is Peuquet.
And who do you represent in this proceeding?
I represent Public Service Company of Colorado.
And do you sponsor direct and rebuttal testimony in this proceeding, respectively marked as hearing exhibit 101 and 105?
Yes.
Okay, Mr. Piquet is available for cross.
Great, thank you very much, Mr. Manchel. And it looks like UCA is up.
Morning, Mr. Piquet.
Good morning, Mr. Ritterson. Good to see you again.
Yes, it's good to see you. We know each other, but my name is Patrick Wittershine. I'm an attorney on behalf of the UCA, for anyone I haven't met here. Now, you testified that the regulatory background of this proceeding begins in January 2023 in proceeding number 23L-0325G. Is that correct?
Yes, the regulatory backdrop to it. That's correct. Not the actual operations of CNG and LNG that are discussed throughout the proceeding.
Okay. And what type of proceeding was that? 23L-0040G?
It was an application to revise the company's quarterly GCA rates. It was a less than statutory notice application.
So that application included approximately $4 million of costs related to the procurement of LNG commodities and services, right?
Yes, approximately.
Okay. Now, in that proceeding, what was the difference between LNG commodity costs and services?
I don't recall off the top of my head what the specific commodity costs and any other upstream services or other costs related to LNG were in that proceeding.
Okay. But more generally, can you tell me what the difference between LNG commodity costs and other services are?
Yes, the commodity cost refers to the actual, molecules flowing through the pipe, and so that the cost of that resource, and other services are all encompassing for all other costs in order to effectuate the delivery of that commodity through the company's gas facilities. And so it's upstream costs more broadly.
Mm-hmm. So in 23L-0040G, did the commission allow recovery for these LNG commodity and services costs in the GCA?
They did not. In the winter of 2023, they requested more information, which is what brings us all together here today.
Okay. And now you're familiar with decision C-23-0059 in that proceeding, right?
Yes.
Could we please pull up hearing exhibit 400, attachment CWS2? Thank you. Now, in this decision, C-23-0059, did it denied the company's application to allow GCA recovery of both LNG commodity and service costs?
It denied recovery, but didn't make any determinations regarding the appropriateness of these types of costs in GC applications in general. It simply requested more information to be brought forward.
And you testified that the plain language used by the commission in this decision should be the guidepost for this proceeding's additional information on LNG and CNG costs. Is that correct?
Yes, I believe I did.
Okay. Can we please turn to page number 6, paragraph 17 of this decision? Thank you. Mr. Piquet, can you see paragraph 17?
I can. Yeah, it's a little small, but I can see it.
Mr. Rittershine, which sentence or sentences do you want to focus in on?
Well, we can start at the beginning, if that's okay, Ms. Kunkel. Just page 5 there. Could you please read that to yourself, Mr. Piquet, and let me know when you're finished?
You said the first 2 sentences, Counselor?
From the beginning of paragraph 17 until the end of this page, please.
Sure. Okay.
Thank you. Ms. Kunkel, could we turn to the rest of this paragraph on the next page? And Mr. Piquet, could you please finish reading the paragraph?
Okay.
Thank you. Now, the last sentence of that paragraph states, Public Service states it intends to file an advice letter and tariff to modify the GCA to include costs associated with LNG and related LNG services as recoverable through the GCA. Is that correct?
Yes.
And do you agree that the company made the statement as described in paragraph 17?
I'm sorry, could you repeat the question?
Do you agree that the company made that statement?
Referred to in the last line here, that it intends to file
the
an
last
advice letter to modify the GCA. I assume that was made in the actual application itself, but I'm not familiar with the exact reference.
Okay. So in this proceeding, the company filed an advice letter and tariff modifying the GCA to include costs associated with LNG as recoverable through the GCA, correct?
Yes.
So let me just ask, Mr. Rittershine, you said this proceeding. Which proceeding are you talking about?
In the current instant proceeding.
Okay, great. Thank you.
0325G. Thank you, Your Honor. Now, Mr. Piquet, did Public Service file an advice letter and tariff modifying the GCA to include costs associated with related LNG services as recoverable through the GCA?
Yes, that's what we're talking about in this proceeding. The company's made a few adjustments to the GCA tariff.
Mm-hmm. And those adjustments are intended to cover related LNG services.
Those adjustments seek to modify parts of the company's GCA tariff to make it very clear what types of gas costs are flowing through this recovery mechanism.
Okay, thank you. Ms. Kunkel, could we please move to paragraph 24? Thank you. Mr. Piquet, can you see that?
Yes.
Can you please read paragraph 24 and let me know when you're finished?
Sure. Okay,
Now, paragraph 24, it begins, however, we are troubled by the request for variance from the tariff for LNG costs and for the inclusion of these costs in the calculation of the GCA. We share the concerns raised by the UCA in its protest letter, along with additional concerns surrounding the safety of LNG in the selected areas. Is that right?
yes,
Now, have you reviewed UCA's protest filed in 23AL-0040G, which expressed UCA's concerns?
I have in the past, yes.
Okay. Do you recall UCA's concerns?
In general,
Okay. They're actually listed in paragraph 20 of this decision. Ms. Kunkel, could you please turn back to paragraph 20? And just the first page of paragraph 20 is okay. Thank you. So, Mr. Paquet, in this proceeding, did Public Service address the concerns raised by UCA and shared by the Commission? And I'm talking about our current proceeding.
I'm sorry, could you repeat the question? Are you asking me to go through the UCA's concerns one by one?
No, just in general, does the company believe that they've addressed UCA's concerns?
Yes, we believe we have.
Okay. And in the current proceeding, did the company address the safety risks associated with deployment of LNG that the Commission indicated they were concerned with?
We provided details on the use of more specifically LNG. The UCA did not bring up specific concerns regarding safety. So that topic wasn't explored in detail, but it was addressed.
Okay. Ms. Kunkel, could we please turn back to paragraph 24? Thank you. So the additional concerns surrounding the safety of LNG in the selected areas in the second sentence there were not addressed in this proceeding?
At a high level.
Okay. In paragraph 24, the next sentence, the third sentence of the paragraph, that says, we find it is not in the public interest to approve unanticipated costs through the GCA that have not been fully explained and supported or previously addressed in other proceedings. Doing so is not a guarantee of automatic recovery of those costs through rate riders. Now, what do you think those costs means in that sentence?
Those costs seems to be a pretty broad phrase regarding CNG and LNG in general.
And in the next sentence, it says that they are best addressed in separate proceedings, correct?
Correct.
Okay. How many proceedings is the company planning on initiating to address those costs?
The company plans to address its use of CNG and LNG in lots of procedural venues, including this one, right? But I think this can be a topic for further exploration in the company's gas purchase plans filed in June of every year, and the company's gas purchase and deferred balance reports filed in October of every year, in gas rate cases to the extent that there are costs included in any test years. In addition to any ongoing quarterly or interim GCA filings like we saw this past January. So there are a lot of venues in which this will be discussed or could be discussed.
And in this specific venue, 0325G, this addresses the tariff change to allow LNG and CNG commodity cost recovery through the GCA. Is that correct?
Yes, that's the only change the company is recommending at this time, is a few targeted adjustments to the commodity definitions in the company's GCA tariff.
Does the company have any plans to initiate a proceeding modifying the GCA to include costs associated with related LNG services as recoverable through the GCA?
Not at this time.
But wasn't that why the company removed the LNG commodity and service costs from its GCA filing in 23L-0325G?
The company denied that application in January because it was seeking more information, which we've been, highlighted in this paragraph in particular. And so that the company brings forward that information, particularly in the second to last sentence here, right? The company, we instruct the company that such inclusion must be based on substantially more information than presented in this record. This record and this proceeding that we're discussing here today provides that context and that more information.
Thank you. I think you said the company denied the application, but did you mean the commission denied the application?
Yes, thank you.
Thank you.
Thank you
Ms.
for
Kunkel,
that clarification, Mr. Witterstein. That was, I was going to jump in as well to clarify that. Thank you.
Of course. Ms. Kunkel, could we please pull up hearing exhibit 102? This is Mr. Piquet's rebuttal testimony. Could we please turn to page 21, line 6? Thank you. Mr. Piquet, can you please review lines 6 through 10 and let me know when you're finished?
Okay.
Thank you. Is there a typo on the year indicated in your testimony?
Yes, that would be 2023 rather than 2022. Okay. Thanks for calling that out.
So replacing 2022 with 2023 would make this testimony accurate?
Yes.
Okay, so you testified the commission denied the company's interim GCA filing to be effective on February 1st, 2023, and the company subsequently refiled an updated interim GCA filing for February 23 that removed the commodity and service costs related to LNG to allow these topics to be addressed in a separate forum. Is that correct?
Yes.
Okay. Ms. Kunkel, could we please turn back to hearing exhibit 400, attachments CWS2, paragraph 24. Thank you. Now, Mr. Piquet, as you indicated earlier, this paragraph says, if public service wishes to include them in its GCA, we instruct the company that such inclusion must be based on substantially more information than presented in this record. Did I read that correctly?
Yes.
And so this sentence instructs the company on how they can include LNG costs in its GCA recovery.
Yeah, it says if we wish to include them in the GCA, it must include substantially more information. And so we're providing that broader context here, and to the extent to which there's any CNG or LNG costs in future GCAs, there would be additional information provided at that time as well.
Mm-hmm. But in this proceeding, the company is only asking for a tariff notification to allow for GCA recovery of the LNG, CNG commodity costs. Is that right?
No, I would characterize it differently, Mr. Witterstein. I would say that the targeted tariff adjustments that the company is seeking approval of address the commodity portion of the company's GCA tariff, because we think other adjustments were not necessary.
Mm-hmm. Okay, I just want to make sure we're on the same page with the costs that we're discussing. So the costs associated with related LNG services, as the commission described them, those are the same as upstream costs, right?
I would disagree. I think when the commission is referring to LNG costs and related costs, it's all encompassing everything regarding the costs of these resources and the costs to bring them onto the company's system. Okay. It's not specifically the commission did not specifically use the terms commodity or upstream or anything like that. It was using much more broad language.
What does the company consider are upstream costs?
Upstream costs as defined in the company's tariff.
Okay. Upstream services are defined in commission rule, right?
Yes, and I believe there's a reference to that in the company's tariff as well.
Ms. Conkle, could we please pull up hearing exhibit 402? Thank you, and scroll down to Rule 4601GG. Thank you. And Mr. McKay, this is where upstream services are defined in commission rules.
Yes, that's correct.
Thank you. Your Honor, BCA would request you take judicial notice of the commission's definition of upstream services.
I'll go ahead and take administrative notice of that.
Thank you. So now, Mr. Piquet, is it accurate to describe the company's goal following this proceeding is to recover all commodity and upstream costs related to the deployment of LNG and CNG through the GCA?
I'm sorry, I missed a word at the beginning there. Could you say that again?
Sure. Is it accurate to describe the company's goal following this proceeding is to recover all commodity and upstream costs related to the deployment of LNG and CNG through the GCA?
It's the company's proposal would be to recover, applicable CNG and LNG costs through the GCA that are for third-party services. So with that additional context that this is for third-party services and not company-owned projects or facilities, yes, we think the GCA is an efficient mechanism both for the company as well as for its customers.
Thank you. Ms. Kunkel, could you please pull up hearing exhibit 400, attachment CWS 4? Thank you. And scroll down a little. Thank you. Mr. Piquet, are you familiar with this document?
Yes.
Okay. And Alexander Trowbridge was the sponsor, but you're adopting his testimony and discovery sponsorship. Is that correct?
That's correct.
So in the second paragraph here, it specifies actual LNG costs from the 2022 to 2023 winter season. Is that right?
Yes.
And what months does the company consider to be its winter heating season?
Well, it's defined here as October through April. I've seen a few other definitions, but for the time being, I think that applies.
Does that vary by location?
It can.
So is the heating season longer in the company's mountain service areas than it is in Denver?
It can be, although I'll have to confess I'm not a gas planner. So there could be different definitions internal to the company.
So turning back to these costs, did the company request prior commission approval for the 2022 to 2023 winter LNG deployment?
We did not request prior approval for these. The application in January for the interim GCA change was the first time I believe we brought forward these costs for recovery, or a portion of these costs rather.
So this cost breakdown provided by the company, it indicates the upstream non-commodity costs were over $5.8 million, while the commodity cost of the actual LNG was just over $100,000. Is that correct?
That's correct.
And what are the four primary categories that the company has summarized for the upstream service costs of LNG?
I believe, as this discovery response will lay out, that there's several items as part of the upstream services cost. If I misstate what the four main ones are, apologies, but generally we're talking about all the costs to effectuate delivery of that commodity onto the company's system. And so in this case, that was trucking and the transportation of that commodity, site preparation costs, as well as equipment rentals to make sure that there are compressors, odorizers, vaporizers on site to actually transform that liquefied natural gas into a form where it can be injected into the company's system. And so those are some of the main costs we're talking about here, equaling about 5.8, 5.9 million over the last heating season.
So can I direct your attention on the right side of this paragraph? On the 8th line from the bottom, I think that the company has summarized these categories. And the company provided the four primary categories of upstream service costs for LNG of storage, transportation, site preparation, and other related costs. Does that sound like the four main categories?
Yes.
Okay. Ms. Kunkel, could you please pull up hearing exhibit 102?
Let me just interrupt for a moment and ask, what was the hearing exhibit number, the exhibit we were just looking at? I know it was 400. I don't know what the attachment was.
That was hearing exhibit 400, attachment CWS4.
Thank you. Sorry for the interruption. Go ahead.
Thank you. Please turn to page 26. Now, Mr. Piquet, on line 6, you testified that trial staff finds that the GCA allows recovery of the commodity portion of LNG CNG resources, as well as upstream service costs. Is that right?
Yes.
And in support of that statement, you cited Ms. McGee of trial staff's testimony at page 3, lines 4 to 7.
Yes.
Ms. Kunkel, could you please pull up hearing exhibit 300? This is Ms. McGee's answer testimony. And please turn to page 3. Mr. Piquet, could you please read to yourself staff's recommendations from line 4 to 7 that you included in your citation? And let me know when you're finished.
It says, oh, sorry. Okay.
Thank you. Now, in the summary of their recommendations, staff recommends that the commission define what costs may be recovered through the GCA, and based on this, the commission then decide to either approve or disallow PSCO's proposed changes to its tariff, right?
Yes, that's what staff says.
And in the summary of their recommendations, does staff suggest that any specific costs be allowed or not allowed recovery through the GCA?
Yes, they discussed that a few pages down.
And in this citation supporting your testimony, does staff include a finding that the GCA allows recovery of anything at all?
In this specific couple lines, the staff is not as clear as it is further down, which is what the purpose of my testimony was. The intent of my testimony was referencing is the more nuanced opinion of staff on this topic.
Ms. Kunkel, could we please turn to page number 8? the sentence beginning on line number 9 says, the inclusion of non-commodity and upstream service costs violates the purpose of the GCA. Is that right?
That's what staff says in that line. However, they're more nuanced in other parts of their testimony, saying that certain upstream service costs are reasonable for inclusion, but staff called out 3 categories that they took issue with.
Okay. Ms. Kunkel, could you please scroll down to line number 15? And so in this testimony, Ms. McGee identifies site preparation fees, rental fees, and security costs as non-commodity and upstream service costs that PSCO is improperly proposing to include in the GCA, right?
Correct. That's what they say right here.
Now, what were the 4 categories of LNG upstream costs that we listed earlier?
Transportation, storage, site preparation, and other.
Okay. So Ms. McGee's testimony identifies 3 of the 4 categories the company has listed for upstream costs associated with LNG deployment as essentially inappropriate for GCA recovery.
I would disagree with that characterization. It's not 3 out of the 4 categories. It's a few of the components of upstream costs that they take issue with, not 3/4.
Ms. Kunkel, could you please pull up hearing exhibit 400?
Can I ask a question? Did you say not the 3/4 or not the, I didn't get the end of his answer, Mr. Bouquet.
Yes, it was not 3/4 area.
I apologize, Ms. Kunkel. I meant attachment CWS 4 of hearing exhibit 400. Thank you. And scroll down to that larger second paragraph of the response. Thank you. Now, Mr. Piquet, I'm going to try to guide you to the descriptions of the cost categories in this document. Please just let me know if I'm being unclear. On the 7th line from the bottom, towards the right-hand side of the page, a sentence starts with storage and transportation costs are comprised of. Do you see that?
I'm sorry, I'm not finding the exact reference. Could you say that again?
On the 7th line from the bottom of the page, a sentence begins with the words storage and transportation costs are comprised of.
I see.
Okay, thank you. So that says storage and transportation costs are comprised of the total monthly rental costs for all equipment required to store and operate the facility, including mobilization and demobilization costs, correct?
Yes.
Okay. And the next sentence deals with transportation costs.
Yep.
Sentence after that says site preparation costs include installing a pipeline connection point to the gas system, location grading and civil work, fencing, and electrical connections, right?
Yes.
And in the next sentence, it says other related costs primarily include 24/7 security while LNG is on site and call out costs for operation.
Yep.
Okay. Ms. Kunkel, could we please return to hearing exhibit 300, page 8, line 15? Thank you. Now, Mr. Piquet, according to the discovery response that we just reviewed, storage fees are comprised of monthly rental costs. which Ms. McGee testified are improper for GCA recovery, right?
Yes. Staff takes issue with rental fees as described here, and that is a component of the, I believe, the storage category that we just reviewed in the company's response.
And site preparation costs is another category of upstream costs. Ms. McGee has testified is inappropriate for GCI recovery.
Yes.
And Ms. McGee also testified that security costs are inappropriate for GCI recovery.
Yes.
Okay. Thank you. I'd like to shift gears and ask you a little bit about your testimony concerning affordability for ratepayers. Ms. Kunkel, could you please turn to hearing exhibit 102, Mr. Piquet's rebuttal testimony? And page 10, please. Thank you. Go down to line number 10. This is good, thank you. So on line number 10, Mr. Piquet, you testified, affordability is no doubt an evolving concept at the commission, which is appropriately being addressed on a more holistic basis elsewhere by the commission. Is that correct?
Yes.
Now, what did you mean by affordability being an evolving concept?
Meaning how it is defined and brought to bear in commission proceedings. It is an evolving concept and a very active subject of discussion at the commission at the moment.
Okay. Ms. Kunkel, could you please pull up hearing exhibit 406? Thank you. Mr. Piquet, you recognize this document?
Yes.
What is this?
This is a company response to a UCA discovery request.
And you're listed as the sponsor of this response.
Yes.
Is it still accurate today?
Yes.
Thank you. Your Honor, UCA moves for admission of hearing exhibit 406 into the record.
Is there any objection?
No objection.
Hearing exhibit 406 is admitted.
Thank you. Now, Mr. Piquet, this says the commission is continuing to work on its approach to affordability in other proceedings and in its own affordability initiative work plan without a definite or binding application of the concept at the moment, right?
Correct.
Now, in general, does the company have a way to determine the rate impact of its proposals?
Yes. When there's a bill impact, we bring forward that information in its filings.
So is that also known as a bill impact analysis?
Yes, that's one component of affordability.
And does this bill impact analysis quantify the impact on affordability for various customer classes?
Yes, the bill impact is quantified for various customer classes.
Does the company have any other way to quantify the impact on affordability of its proposals?
Yeah, more broadly, we're talking about cost benefit analysis here, whether quantitative or qualitative. And lots of proceedings deal with that question. So bill impacts are not the only way to think about affordability.
Now, you've testified that LNG and CNG resources, they have an important role to play as a bridge resource to allow the company to avoid, defer, or mitigate more traditional gas pipeline projects. Is that correct?
Correct.
Ms. Kunkel, could you please pull up hearing exhibit 414, 414? Thank you. Do you recognize this document, Mr. Piquet?
It looks like a company response to a UCA discovery request.
Ms. Kunkel, could you please scroll down to the sponsorship? Were you listed as the sponsor of this response, Mr. Piquet?
Yes, I was.
Thank you. Ms. Kunkel, could we please scroll up to the response there? Thank you. Do you believe this is still accurate today, Mr. Piquet?
The entirety of the response or a particular subpart?
The entirety.
Yes.
Thank
It's still accurate.
Your Honor, UCA moves to admit this to the record.
Any objection?
No objection.
Hearing exhibit 404 is admitted. Or is this 414?
This is 414.
Okay, I apologize. I amend what I just said. Hearing exhibit 414 is admitted.
Now, Mr. Piquet, in response, Part C, does this state that use of temporary LNG/CNG resources allows for consideration of non-pipeline alternatives?
I'm sorry, Counselor, are you quoting from subpart C or are you referring to the question?
I believe I was quoting from subpart C. Apologize if that was inaccurate. Well, we can move on. So, in general, would you say that the use of LNG and CNG resources, they allow for the consideration of non-pipeline alternatives?
So if we take a step back, yes, that's one of their purposes,
Mhm.
right? I would consider it twofold. The use of CNG and LNG as temporary solutions can allow the company more time to continue to study longer term solutions that are the most cost effective, and also be a bridge, so to speak, for the implementation of cost effective non-pipeline alternative portfolios. And so, those types of electrification or energy efficiency or conservation measures take time to implement. And so, in that case, CNG and LNG can be a bridge to the implementation of those longer term solutions. So either to use to kind of study the solution and or implement the actual solution, we think LNG and CNG play a vital role moving forward.
Okay. And so these non-pipeline alternatives that you mentioned, they're also known as NPAs. Is that correct?
That's correct.
Is there an ongoing holistic planning process that allows the company to determine when to employ NPAs and when to employ more traditional gas pipeline infrastructure projects?
The company's gas infrastructure plan proceeding, which is currently ongoing in an M docket before the commission, seeks to address planning for the company's gas system more broadly. This first instance of it is non-adjudicated, but yes, GIPs tend to deal with gas infrastructure projects and NPAs around those projects when applicable. Of course, there's a whole suite of conditions which we don't have to go into here, but yes, gas planning and NPAs are certainly a subject of GIPs.
Ms. Kunkel, could you please pull up hearing exhibit 419? Thank you. Scroll down to Rule 4550. This is the overview and purpose of the gas infrastructure planning process. Is that right, Mr. Piquet?
Yes, these are the commission's rules. regarding GIPs.
Thank you. Your Honor, ECA requests you take administrative notice of Rule 4550.
I will take administrative notice of Commission Rule 4550. Go ahead.
I'm sorry, Your Honor, are we just introducing this one rule? It looks like it. This is not all of the GIP rules. It's just this one GIP rule. Is that right?
That was my intention.
Thank you.
Ms. Kunkel, could you please pull up hearing exhibit 408? Thank you. Do you recognize this document, Mr. Piquet?
Yes.
Can you please read me the date of this response?
The response date was November 9th of this year.
And you're listed as the sponsor of this.
Yes.
Your Honor, ECA moves to admit this discovery request, hearing exhibit 408 to the record.
Any objection?
No objection.
Hearing exhibit 408 is admitted.
Thank you. Now, Mr. Piquet, in response part B, the second sentence, it says, regarding new resource needs in mountain communities, the company has been working collaboratively with regulatory and community stakeholders in recent months to discuss options and alternatives for addressing capacity expansion. This mountain energy project is still being developed and was in the early planning stages at the time the company filed its initial gas infrastructure plan, and thus was not ready to bring forward at that time. Is that correct?
Yes.
Thank you. Ms. Kunkel, could you please pull up hearing exhibit 401 from ECA's box? Your Honor, this was a public comment letter submitted in docket 23M-0464EG. ECA requests the Commission take administrative notice of this letter that is already in Commission's files.
Okay, so it's 23M-0464EG.
That's correct.
Okay. Any objection? And Mr. Mansholt, if you need time to review this, let me know.
I could just reserve comment till we scroll to the end. Mr. Wittershe, maybe you could help me clarify. There's no other attachments from this comment letter. This was just the only letter.
It is the only letter that I'm aware of, yes.
I'm sorry, this letter wasn't accompanied with an attachment.
Oh, no, I don't believe so.
Okay, no objection.
Okay, hearing exhibit 401 is admitted.
Thank you, Ms. Kunkel. Could you please scroll down to the contents of the letter? Thank you, right there. Scroll up just a little bit. Thank you. Now, Mr. Piquet, this letter is dated October 26th, 2023, correct?
Yes.
Thank you. And Ms. Kunkel, could we scroll down so we can see the third full paragraph of this? Mr. Piquet, could you please review that paragraph starting with, "We have been Energy Futures partners," and let me know when you're complete.
Sure.
Thank you.
Okay.
So on the fifth line from the bottom of that paragraph, a sentence begins with so much so. Can you see that?
Yes.
Okay, so that continues. We're in debate with the utility over the cost and need of an upgraded natural gas pipeline they claim is needed to service growth in our mountain community, while all our goals and policies are striving and driving toward a fossil fuel-free future. We'd like to see future investment in upgraded systems and the interconnection and transmission of electricity, not natural gas. Did I read that correctly?
Yes.
And so the company has a holistic gas infrastructure plan filed with the commission to determine the need for and potential alternatives to capital investment. Is that right?
Yes.
But the company has chosen to address GCA recovery for LNG and CNG commodity costs in this proceeding.
We are addressing third-party CNG and LNG services in this proceeding. What this is referring to is that more holistic planning process that I referenced in the discovery response that you brought up a moment ago. You know, we're looking at a whole bunch of alternatives at the moment, working in partnership with Town of Breckenridge and other communities up there and other customers and other regulatory stakeholders to find out what is the most efficient long-term solution. And we haven't yet proposed on either a preliminary basis or an actual filing on what that solution may look like. We're still taking in feedback, just like what we have in front of us at the moment, and are studying the potential options in front of us.
And so the company's mountain energy project, that will be presented to the commission at a later time in a different proceeding?
Yes, if there was a proposal to bring forward for approval, the company would do so at that time. There was nothing to bring forward for discussion in detail or for approval in the company's initial GIP, which was filed in May of this year, I believe.
So if the company's position that the prudence review included in the GCA rules will provide an adequate prudence review of the costs of LNG deployment, correct?
I think the company's testimony is that there are a plethora of opportunities for the company and other interested parties to discuss the use of CNG and LNG in its operations. You know, the number of proceedings that I talked about previously, the company believes that is quite robust as procedural avenues. Yes.
Now, is the gas purchase plan subject to a prudency review by the commission?
The gas purchase plan is deemed complete by the commission.
Council, could you please pull up hearing exhibit 403? This is Commission Rule 4605. You please scroll to Part C. Thank you. Your Honor, UCA requests the Commission take administrative notice of their Rule 4605.
I'll take administrative notice of it. I'll just say that, you know, I'm allowed to take take administrative notice or just rely on all of the commission's rules. So I guess perhaps there's a benefit to having this in the record to the extent it went up on judicial review. So I'm just thinking out loud here, wondering about the benefit of actually including as exhibits individual commission rules. So why don't we go forward? I see a limited benefit potentially to having this in the record. So go ahead. I'll admit it and go ahead.
Thank you, Your Honor. So, Mr. McKay, you talked briefly about gas purchase plans being deemed complete just earlier, right?
Yes.
So under Rule 4605C, the Commission assigns a proceeding number and reviews the submittal solely for completeness. Is that correct?
Yes, that's my understanding.
Okay. And the commission does not hold a hearing on the substance of the GPP, allow interventions, require testimony, permit discovery, or make a decision approving or disapproving the substantive information contained in the submittal. Those are all things the commission does not do, right?
No, there's not a litigated process, Counselor, but the commission does tend to discuss this at one of its weekly meetings. So there is discussion of it, I would say.
Now, the GCA prudence review that you refer to in your testimony, that's available when the company files its gas purchase and deferred balance reports. Is that correct?
Yes, that's correct. And just to take a step back, right, if we think about the entire process, right, of filing a GPP in June that covers the upcoming 12-month period from June through July, that preceding 12-month period, you know, there's quarterly and interim GCAs during those 12 months. And after the conclusion of that, the company submits its gas purchase and deferred balance report in October the following year. And so there's, you know, between all of those filings, the company believes there's a robust process to review the company's gas purchases and gas operations.
Thank you. Ms. Huffle, could you please pull up hearing exhibit 418? Thank you. Scroll to Part B. Thank you. Your Honor, this is the last time I believe UCA will request you take administrative notice of a commission rule. This is Rule 4608.
And is it the entirety of 4608?
Yes, Your Honor.
So you're requesting administrative notice of Commission Rule 4608, is that correct?
Yes, Your Honor. Thank you.
And it's hearing exhibit 418. So I'll take administrative notice of hearing exhibit 418, which is Commission Rule 4608. Go ahead.
Thank you. Now, Mr. Piquet, under this rule for the gas purchase and deferred balance report, including the results of any active GPIM or gas performance incentive mechanism, the commission may initiate a prudence review hearing. The prudence review may result in tariff or rate changes that could affect different classifications of customers. Is that right?
Yes, that's what it says in subpart B.
Now, in your experience, Mr. Piquet, has the company been disallowed any GCA cost recovery within the past 10 years?
I'm not aware of any disallowances.
Okay, thank you. Ms. Kunkel, could you please pull up hearing exhibit 411? Thank you. Mr. Piquet, do you recognize this document?
Yes,
And you're listed as the sponsor.
correct.
Is the response still accurate today?
Yes, correct. There was a review of the company's gas purchases back in 2013, but there were no disallowances, according to my understanding.
Thank you. Your Honor, UCA moves for admission of hearing exhibit 411.
Any objection?
No objection.
Hearing exhibit 411 is admitted.
Mr. Piquet, do you know if there were any disallowances for GCA recovery prior to 2013?
Not that I'm aware of.
Now, in your rebuttal testimony, you calculated the $6 million for LNG costs for the 22 to 23 winter season as representing only 0.64% of GCA costs over the 6-month period of October 2022 through March 2023. Is that correct?
Correct.
And you also concluded that the third-party LNG costs are in fact non-material. Is that right?
Yes, I believe that was the term that I used.
Do you think the commission would initiate a prudence review of non-material costs?
I can't opine on what the commission would or would not investigate. Certainly everything is within its purview.
Okay. So you've testified the company is exploring prudent and safe methods to avoid, defer, or mitigate more traditional gas pipeline projects. Is that right?
Can you refer me to the section of my testimony where I say that?
Sure. Ms. Kunkel, this will be hearing exhibit 102 on page 14, please. Lines 20 through 23.
Thank you. Yes. Yes, generally that is what I say.
So who determines if deployment of LNG and CNG resources are prudent and safe methods?
The company has a responsibility to make sure that it provides safe, reliable, and affordable service to its customers at all times whenever they demand it. And the commission certainly has jurisdiction over those types of activities.
So the company filed its fourth quarter 2023 GCA filing on September 15th, 2023. Does that sound right?
Yes, that sounds right.
And that was captioned as proceeding number 23AL-0325G, right?
That sounds right. Subject to check.
Ms. Kunkel, could you please pull up hearing exhibit 420? Mr. Piquet, you recognize this document, right?
Yes.
Okay. Can you tell me what it is?
I believe it's the company's fourth quarter 2023 GCA application filed in mid-September to be effective on October 1st.
And you're the company representative who signed the affidavit verifying this application?
I believe I was.
Okay. Your Honor, ECA requests the commission take administrative notice of this verified application.
Any objection?
Just to understand, this doesn't include attachments or anything. This is just the complete application. Is that right, Mr. Wittershein?
Yes, this is just the application. I may ask a question about the attachments, but that's not included in this exhibit.
I haven't seen this. This is a complete copy, but I'm assuming it is. No objection.
Okay, hearing exhibit 420 is admitted. And Mr. Wittershein, I would just note, I mean, as we can all read at the top of this, there's a notice of confidentiality. Just be aware of that. You said you would have a question or two about an attachment or two to this application. Just be aware of any potential confidentiality issues. If anything that is the subject of a question or anything that you're going to show on the screen has confidential information in it, just give me and Ms. Kunkel a heads up on that. Go ahead.
Yes, Your Honor. Thank you. Now, Mr. Piquet, you're familiar with the contents of this document, right?
Yes, generally. It's been a couple months, but yes.
Did the company include any LNG costs in its fourth quarter 2023 GCA filing?
I do not believe we did.
Okay. But the company is deploying LNG to the Breckenridge area for the 2023 to 2024 winter heating season, correct?
Yes, we are.
Okay. Does the company plan on including the upstream LNG deployment costs for winter heating season 23 to 24 in a future GCA for cost recovery?
I think it depends on the outcome of this proceeding, as well as the company's determinations. Apart from that, there are no firm plans one way or the other.
Wasn't it in your testimony that the company would seek to recover third-party LNG costs in a future GCA application?
Yes, the company would like to have the GCA mechanism be an avenue for recovery of third-party costs. Yes. I'm simply saying at the moment we don't have specific plans to do so in an upcoming quarterly filing. But certainly we would like to have the option of doing so.
Could you please pull up hearing exhibit 415? Thank you. Mr. McKay, this is the company's response to UCA discovery request 29, correct?
Correct.
And you're listed as the sponsor.
Yes.
Is the response still accurate today?
Yes, it is.
Your Honor, UCA moves to admit hearing exhibit 415 into the record.
Any objection?
No objection.
Hearing exhibit 415 is admitted.
So when the company seeks recovery, or if it does, it will include the $6 million in its GCA deferred account. Is that right?
I'm sorry, Counselor, your question is if the company seeks to recover LNG costs through the GCA?
Yes.
Then it would include any and all appropriate costs at that time. It's hard to say what that amount would be.
So if the company does seek recovery through its deferred account, how will it let the commission know that that is occurring?
It would spell that out in the GCA application itself. And that information would be provided in the required attachments to the GCA, of which there are many.
Uncle, could you please pull up hearing exhibit 416? Thank you. Mr. Piquet, this is the company's response to UCA discovery request 31, correct?
Yes.
And you're the sponsor of this?
Yes, I am.
And it's still accurate today?
Just give me one moment to glance at it. Yes, it is still accurate.
Thank you. Your Honor, UCA moves to admit hearing exhibit 416 into the record.
Any objection?
No objection.
Hearing exhibit 416 is admitted.
So, Mr. Piquet, in response part A, the last sentence says, when the company makes a firm proposal for cost recovery of specific third-party LNG/CNG resource costs, actual cost concerns and such would become ripe for discussion. Is that right?
That's correct.
And in the company's view, what are some of the concerns that would become ripe for discussion?
Objection, Your Honor. This calls for speculation. There's no actual cost recovery request in this proceeding. In the future, the company can't speculate what those cost concerns by other parties may be.
I'm going to overrule and let Mr. Piquet answer the question. Go ahead.
Actual cost concerns would be whatever the commission or any intervening party thought those concerns could be. And so I can't say sitting here today that I know what those are. You know, the UCA previewed some of its concerns and its protests to the company's GCA earlier this year, and some of which are part of its testimony in this proceeding before us today. So I'd imagine it would be something similar, but of course it's impossible to know what any concerns, if any, would be raised at that time.
Thank you, Mr. Piquet. Ms. Kunkel, could you please pull up hearing exhibit 409? Mr. Piquet, do you recognize this document?
Yes.
You're listed as the sponsor,
Yes, I am.
and this is still accurate today.
Yes.
Your Honor, UCA moves to admit hearing exhibit 409 into the record, please.
Any objection?
No objection.
Hearing exhibit 409 is admitted.
Now, Mr. Piquet, you've testified about a typical utility response to a gas capacity constraint. Do you remember that?
Yes.
Ms. Kunkel, could you please pull up hearing exhibit 417? Thank you. Mr. Piquet, you recognize this document?
Yes.
You're the sponsor,
Yes, I am.
and this is still accurate today.
Yes, it is.
Thank you. Your Honor, ECA moves to admit hearing exhibit 417 into the record.
Any objection?
None.
Hearing exhibit 417 is admitted.
Now, Mr. Piquet, Part A indicates that LNG and CNG utilization is an atypical effort, right?
Atypical in the sense of looking at what we've been doing historically and not a typical quote unquote gas infrastructure investment to address a capacity constraint. Yes.
So atypical efforts are those that deviate the gas system operation from its normal design. Is that right?
With a view towards what's been done historically. Yes.
And the atypical response in this case is intended to mitigate existing capacity constraints. Is that right?
Yes.
So prior to the company's use of LNG and CNG resources, how would the company address a capacity constraint?
I would view it more broadly. If we think about normal gas utility operations, prior to the introduction of our new clean heat and GIP rules, some of which we've been talking about here today. And so, typically, if we think about, and use typical in a historical sense, right? If we think about gas utility operations when there's a capacity constraint, that has often historically been addressed with a new capital investment for either installing new pipeline and or increasing the capacity of existing pipelines. I think what we're talking about here are new solutions and temporary measures to try to get around some of those constraints.
Now, what type of approval did these more typical projects require?
A company proposal to build new pipeline or increase existing pipeline would take the form of a filing from the company if it was for company-owned assets. And it met, of course, the CPCN requirements laid out in rules. Not by definition would it be a certain filing, but imagining a kind of large infrastructure project, like we saw a few years ago in the West Metro case, that's more specifically what I'm referring to.
And how did the company typically recover costs for these projects?
For company-owned assets, it would uh, largely flow through a base rate review proceeding or a rate case if if it was not applicable for rider recovery. And I say rider recovery because the company has had, riders in the past, such as the PSIA that covered certain investments. That's not a rider that's in place today, but just for clarity.
Thank you, Mr. Piquet. Your Honor, I have no further questions.
Okay, we are at a little bit after 10:30. Let's go ahead and take our mid-morning break until 10:45. So we'll be in recess until 10:45. Thank you. Okay, is everybody ready to go?
Yes, can I clarify one thing before we get going with Mr. Piquet? I think I don't see him yet. He's still there?
So
Did
it's
you
a
say,
question.
is it, yeah,
It's a question for Mr. Piquet.
yeah, is it prospective meta-analysis, prospective method analysis? I wasn't quite sure what you were saying there. I looked it up because I wasn't sure, so that's right. But is that correct? Perspective, and then you went into quantification?
I'm trying to,
Remember-
yeah, I'm trying to
Remember?
think of the context we were talking about. It was
Okay, let me try to, I can get back.
perspective, but what was the second word you were wondering about?
Well, they said they have meta analysis on the internet, but it sounded like meta or method analysis. When you were,
Can you-
should I find the question?
Yeah, why don't you find the question?
Okay, it'll take me 1 sec here, sorry.
Yeah, sorry, Harriet, I can't recall.
That's okay. Hold on.
And while you're doing that, Ms. Wiesenthal, let me just tell everybody, and we're not on the record. I'm doing this from a different location than normal. I'm confident that my interconnection is more than sufficient to handle this. But if anybody has any issues hearing me in particular, do not be shy about interrupting. And there will be some things that I will try to do to the extent that becomes a problem. I don't think it will, but I just want to make that clear. Do not be shy about interrupting me and telling me that you can't hear what I'm saying. Okay?
Thank you. All right, here's the question. Does the company have any way to quantify the impact on the affordability of the proposals? And then you said yes. More broadly, we're talking about and then it was kind of mumbled. I thought I heard prospective method analysis, whether quantitative or qualitative. Is that any?
Yeah, I think what I was saying there is cost benefit analysis, whether
Okay.
quantitative or qualitative.
Okay, thank you. That's why I was.
Yeah, so I don't think I said the word prospective, but
All right,
Maybe I
it got kind of mumbled sometimes, so
sorry,
that's all
I'll
right.
try to go slower. I know I speak fast sometimes.
Okay, that's all right. Yeah, I know. I remember.
All right, give me just a moment. All right, Ms. Kunkel, I'm assuming that you're ready to go.
Yes, I am. Thank you.
All right, I'm going to need just a moment. Okay, we are back on the record in proceeding number 23AL-0325G. Excuse me, and based on the cross-examination matrix, I do not believe that staff has any questions for you, Mr. Piquet, but I have just a couple by way of clarification. And by the way, I just want to thank you again for being here and providing your testimony. It's been very helpful. But first question has to do with, and I'd ask Ms. Kunkel to call up the hearing exhibit 400 attachment CWS-4. And this is a response to discovery request CPUC 1-5. You fielded a bunch of questions about it, Mr. Piquet, during your cross-examination by Mr. Wittershine.
Yeah.
And I'm focused on the second full paragraph under response and where it carries over, to, is this CWS-4? I think I'm on the incorrect. No, this is correct. Sorry. So what I want to focus on just really briefly, Mr. Piquet, is Mr. Wittershine asked you a series of questions regarding the last half of this answer, going over to page 2. And about halfway down, There's a sentence that starts with, the company has not separately summarized the dollars associated with individual components of upstream service costs. Do you see where I am?
Yeah, right in the middle there, I see.
Yep. And then this discovery response goes on to list the 4 primary categories of upstream service costs. And the one I want to focus on is site preparation costs. And there's a sentence 3 lines up from the bottom. Site preparation costs include installing a pipeline connection point to the gas system, location grading and civil work, fencing, and electrical connections. Do you see where I am?
Yes.
And I'll just be frank, those costs seem distinct to me, distinct from the other categories. But I want you to correct me if I'm wrong. The other costs generally characterized are third-party service costs. They're services provided by third parties. These costs seem to be, well, for want of a better word, I'll say capital costs. They're costs of putting equipment, adding equipment to public services, pipeline system, infrastructure, however you want to put it. And it seems to be costs for equipment that will stay on public services pipeline system or infrastructure system. Am I right about that?
I would, well, good question, and thank you for the question, Your Honor. I would characterize it a little differently. If you're saying it seems like this category seems different or other than these other categories, I would argue that it's actually more similar than dissimilar. And just for clarity, right, all these costs that were originally proposed to flow through the GCA, right, back in January, which we're talking about a lot in this proceeding, are third-party costs. And so, site preparation is not necessarily being performed by the third-party contractor we have delivering the gas and all of the equipment. We're relying on other third-party servicing companies that the company already has contracts with to provide that type of, civil work and fencing and whatnot. And so I'm not saying that there's kind of no company labor or assets being involved. If there is, that is certainly not what we're saying would flow through GCAs. We're talking exclusively about third-party costs. So just to clarify that aspect. And the second piece I would say is, if we take a step back and think about, these upstream costs that the company incurs to bring this commodity into its, owned gas facilities, it's really not a whole lot different than what's going on the upstream side of more traditional natural gas pipelines and upstream providers. It's just that all of those costs, right, that a pipeline operator has to incur for site development and security are kind of baked into that commodity cost that we pay on the upstream side to actually deliver it to our facilities. This just feels different because it's the company having to go and engage in agreements with other third parties to get this gas on site to where it's needed. And so we've got more transparency in that sense that we can actually, right, have a look at all these different categories. But I would argue that it's not like these other upstream providers, delivering natural gas through pipelines are not incurring these types of costs either. It's just, it's baked into that cost that we see. So we don't have that transparency in that sense.
So basically what you're saying is that what's included in the site preparation costs here is included in the price that public service is paying for the gas commodity in the more traditional sense. And therefore,
yes,
these types of site preparation costs are being recovered through the GCA because it's baked into the commodity price that public service is paying. Do I have that right?
That's exactly what I'm saying, Your Honor.
Okay. So, I mean, let me ask you this. So just focusing on that sentence, starting with site preparation costs include. So a pipeline connection point to the gas system, even if that work is done by a third party, that pipeline connection point is going to stay on public services system and become a public service asset, is it not?
Yeah, good question, Your Honor. So on that point, I would say that a lot of this is temporary. That pipeline connection point is likely to move if that site needs to move. And for additional clarity, in our site in Breckenridge, which we've been talking about over the 2022 to 2023 heating season, or we'll be using that site again in the 2023 to 2024 heating season that we're just getting into here. But there's a kind of time limit on the use of that site. And so for various reasons, we're going to need to move that site to a different location. And so are there going to be permanent connections left over? I don't think so. And so I don't think there's any kind of addition to capital resulting at the conclusion of this project or this particular site development. This is kind of designed to be moved around as needed as the company incurs these capacity constraints. Not that this particular solution is quite mobile, but it is a temporary kind of solution of which we've used third-party contractors to develop.
Okay. But the hardware itself, I mean, the actual pipeline connection point, do you know whether that's a public service asset or if it belongs to a third party? And this is separate and apart from whether a third party is connecting and or disconnecting and moving that piece of hardware.
I'm sorry, I just don't know whether that specific pipeline connection point, what exact equipment is entailed to that and who owns it. Just speaking generally about that site development and all the equipment that's needed, the vast majority of that is coming from our third-party contractor here, which is Sapphire Solutions, which is providing a lot of that equipment. The actual trucks, the actual vaporizers, odorizers, compressors, the company doesn't own that equipment for LNG.
Okay. So let me just go through the other, I guess, three things that are listed here, and your answer may be the same. I mean, I understand that you're at a sufficiently high level that you may not know this amount of detail, and I'm not going to hold that against you. I understand and appreciate that. But so the location grading and civil work, I mean, to me, that seems like I don't know what civil work means exactly, but location grading is certainly not going to be undone to the extent this project is temporary and or it moves to a different location. Is that right?
That's a good question, Your Honor. I think what we're referring to here is, are there trees that need to be moved? Is there any paving or concrete work that needs to be established to
Right.
safely house this equipment on a temporary basis? All of that type of work. And again, the company was not using its assets for this. This was all third party provided.
Understood. So the fencing, I'm assuming that's for increased security. And is that third party owned or is that purchased by public service? If you know.
I believe that's third party, Your Honor.
Okay. And the electrical connections, again, you may not know the answer to this, but do they remain when this project ends, or are they temporary and or not owned by public service?
I can't say definitively, Your Honor, so I'm not sure.
Okay, so let me ask you this. I mean, you probably know this record better than I do. I've read everything, but I can't say that I can pinpoint the answer to this question. So these site preparation costs that we've just gone through, have they been disaggregated? And is there a number associated with these site preparation costs in this record, or are they encompassed within a bigger number?
Good question. So as the company said in response to this discovery question, just a couple lines up, but we have not separately broken out each line item or kind of created those subtotals for each of these categories, so to speak. That is something we can do in the future if the commission was interested in that. You know, we have the information. It's just quite a manual process to go through all the invoices and add it to certain categories. So the information exists. It's just that analysis would need to happen. So we have not independently done that yet.
Understood. And I think I know the answer to this next question, which is you don't know the answer to this one either. But so of all the site preparation, I'm sorry, the upstream service costs of which the site preparation costs is a component, I understand.
Right.
Do you have any notion of what percentage of the upstream service costs the site preparation costs represent?
Right. Good question. I can speak generally to it. If we think about these big categories, right, the large costs are coming from, or the majority of costs are coming from trucking these molecules in from our distributor based in the southwest part of the state, storing them on site and all of that equipment, right? What I talked about, the rentals for the storage containers, the vaporizers, the compressors, and then thirdly, the site development bucket. So I would say those three buckets are where we're seeing the majority of costs. And just for a point of reference, right? This came out a bit during the case, but I'm not sure if it was part of testimony of, you know, are other utilities doing this type of work? Particularly this site preparation side of things, which, you know, at first glance might feel and look a little different than what we've seen before. And just, you know, a quick review over the past few days, I found that other utilities are looking at, are using CNG and LNG for gas operations on an increasing basis. This is utilities in California, New York, and just drilling down into one of those specifically, there is, for the utility in New York, I think it's Con Ed specifically, includes these type of LNG costs through its monthly gas adjustment, which is what we're talking about here in this proceeding. And it specifically calls out these types of trucking costs and site preparation costs. It might use the term site development costs. And so it's not like XL Energy is the lone outlier here. I think if we look around the country at gas utilities in general, really trying to solve this question of how do we reduce emissions on a system where it's very difficult to do so. We're having to leave no rock unturned. CNG and LNG provide an interesting solution as a bridge, right, as we've talked about here today, to study other options and to implement other portfolios of, you know, electrification and energy efficiency, other measures that can help us reduce emissions long-term on the gas system.
Got it. And I'm assuming, and this may be in the record already, but just confirm this for me or tell me that I'm wrong. On the storage side of things, public service is not investing, making capital investments on the storage side. It sounds like, I mean, you're using third parties to provide the storage option. Do I have that right?
Yeah, specifically storage for CNG and LNG.
Yes. Yes.
Yeah, on
Sorry.
site, that is equipment that we are renting from Sapphire.
And the reason why public service is not making the capital investment at this time, is it because you view this as at least a potentially temporary solution?
It's because we don't want to rush into an investment before we have a long-term view of the solution, right? We're studying that in real time. We have been studying it for months. We're not ready to bring forward a solution. I think that that letter from the town of Breckenridge, you know, really well encapsulates that. We're talking to our communities in real time here. We're talking with regulatory stakeholders in real time and other customers who have a vested interest in these outcomes to figure out what are the options on the table and what is the best solution. So,
Okay.
So we don't want to go and make large investments before we have a better idea of what that looks like.
Understood. So let me direct your attention, Ms. Kunkel, if you could bring up hearing exhibit 400. And that's the testimony of Mr. Skluzak, I hope. And let's go to the bottom of page 18, please. It's the carryover from 18 to 19. So you may have responded to this, Mr. Piquet, in your rebuttal testimony. I don't remember that you did, but there was this Q&A in Mr. Skluzak's answer testimony, and it starts on line 16 of page 18 and then goes over to line 4 on page 19. And why don't you just read that?
Sure. Okay.
So if you responded to this in your rebuttal testimony, I apologize. But the factual predicate here for Mr. Skluzak's answer is on page 19, line 1 through 2. Essentially, what I'll read it. The actual commodity must revert back to the third-party LNG service provider. And the actual commodity, if we go up to the preceding page, is purchased LNG commodity.
Mhm.
Is the factual predicate accurate?
So, sorry, just a clarification, Your Honor. You're talking about the factual predicate being that commodity cost of the LNG?
Yeah, and that, as Mr. Skluzak says, to the extent it's not used during a heating season, I'm adding a little gloss here, it reverts back to the third-party LNG service provider and is not carried over to the next heating season.
Right. Yeah. Thanks for honing in on this. I think it was something we only briefly discussed in rebuttal testimony. So happy to expand more on it here. It's not correct. The company can't hold on to it until next heating season. So that piece is correct, but it's not like this reverts back to the service provider and they take it away to another site, right? We purchased that commodity. We've purchased the ability to lease and rent all that equipment and develop that site for these 2 heating seasons. And so we used that commodity that we purchased in the 2022 to 2023 heating season. We injected into our system to serve customer load. We just didn't have to inject it for capacity reasons, right? There wasn't an extremely cold day this past winter up in the mountains where it was needed to ensure reliability, because of the natural fluctuations of weather and customer usage. We didn't actually approach those design day conditions. However, we did use that commodity.
Okay, and did Public Service use 100% of the commodity?
Yes, because there's no way, in order for our third-party servicer to kind of take that equipment and deploy it to another site if needed during the months where we don't need it, it has to, I believe the term is a boil off. Essentially, you're just getting rid of that LNG and letting it go into the atmosphere as it warms up. Obviously, that would be a waste. That would be, emissions resulting in no benefit. And so we wanted to inject that commodity into our system to get as much benefit from it as we could. So there's really no option for the commodity to just go back to the service provider.
Okay. So at least one part of your clarification here is that the commodity was used by Public Service. It was injected into Public Service's system. It just wasn't done so for capacity reason. There was no capacity reason to do that, but it was employed and presumably consumed by Public Service ratepayers during the 2022 to 2023 heating season. Is that fair?
That's correct.
Okay. All right. That's all that I have. Thank you for answering my questions, and I will turn back to Mr. Mansholt for any redirect.
Thank you. I think I have 4 or 5 questions here for redirect. Mr. Piquet, just following back with some of the administrative law judge's questions. Can you clarify for these CNG and LNG resources we've been talking about, is the company seeking the ability to recover through the GCA any company-owned assets or facilities or any company labor?
No, we're only talking about third-party costs and services here.
Okay, and so when you talk about the site preparation costs, is it fair to talk about those costs being, like, for instance, the pipeline connection you were discussing in that bucket? Do you have an understanding of whether you're talking about the actual physical asset of the pipeline connection, or is it the labor and process to install the pipeline connection?
It could be both, right? It's certainly the labor and process if we're relying on third parties, but if the actual equipment to connect it into our jurisdictional gas facilities is third party owned, then it would also include that. I'm just not sure who owns those actual physical connections here, if that's being rented or if that's company owned. But what we're talking about in this proceeding is all third party.
So, but if the company owned that physical connection, it would not seek to recover it as an upstream service cost through the GCA, correct?
Yeah, absolutely not. No, that would be germane for a rate case proceeding.
I appreciate that. Going back to some of the conversation with counsel for the utility consumer advocate, I would like to raise from box.com, please, hearing exhibit 109 from Public Services Box. And if we could go down to paragraph 4 on page 4. Do you recall a conversation, Mr. Piquet, with UCA counsel about whether the company intended to file a future GCA tariff revision and whether or not the commission's statement about that intent was accurate or not?
Yes, I do remember that exchange.
Is this the referenced statement from the commission?
Yes, it was here in paragraph 4.
Okay, just for evidentiary record completeness, so we don't have to question whether the commission was summarizing completely or not, or accurately, I'd seek to introduce this hearing exhibit 109 as the new hearing exhibit here.
Okay, and let me ask you this, is this, so a verified application, I think, was already admitted into the record by Mr. Wittershine.
Yeah.
Is this different from that?
Apologies, let me lay a little bit more foundation.
Okay.
If we go back to page 1. Mr. Piquet, could you just explain what this document is?
This looks like it is our interim GCA filing that was made in mid-January 2023 for rates to become effective February 1st, 2023 for the gas cost adjustment specifically.
And was this the company's first request to seek recovery through the GCA of certain LNG costs?
Yes, I believe so.
Okay. And different from this, did you discuss a more recent verified application with UCA counsel that was about fourth quarter of 2023 GCA costs?
Yes, that discussion was about a mid-September 2023 quarterly GCA filing.
Okay. Given that this is our original verified application, which is different than what was introduced in the record, I'd seek to admit this to administrative notice.
Any objection? I'm not hearing any objection, so I'm going to go ahead and admit it. I'll admit it by administrative notice.
Thank you. If we could please turn away from this and turn back to the much discussed hearing exhibit 400, attachment CWS2, please. And we could turn, please, to page 8. And look below at paragraph 24. Mr. Piquet, focusing on the second sentence, and anywhere else in this decision, do you understand whether or not the commission directed the company to specifically address all of the individual issues in the UCA's protest letter?
No, the commission is, in the second sentence in particular, just referring generally to the concerns raised by the UCA, not listing them out one by one in this paragraph or any more specificity.
Has the UCA had an ability to raise any germane concerns in this current instant proceeding regarding third-party LNG and CNG resources?
Yes, and they have.
Would they have an ability in future cases such as other GCA filings or rate cases or et cetera?
Yes, they do.
Okay. Maybe just one last question, and it's a different hearing exhibit. I'd like to open up hearing exhibit 401. This was the comment letter you were discussing about with UCA counsel. If we could scroll down, please, to the following page, page 2. Keep going if you don't mind, please. It actually might be on page, no, actually it's right here. Perfect, thank you. We're on page 2. And I'm looking at this last sentence in the center paragraph, where it says we'd like to see future investment in upgraded systems and the interconnection and transmission of electricity, not natural gas. Do you have any greater feedback about how you consider this letter and the intent of this letter and how you're trying to facilitate the comments?
Yes, yeah, I was glad to talk about this with the UCA. Because I think it shows exactly what we're talking about here in this proceeding, right? The use of CNG and LNG as a bridge resource for us to continue to study, non-traditional solutions. And the traditional solution, as we've talked about, being a new pipeline or a pipeline upgrade project, which can take a lot of time and be quite costly. And so here we are exploring all available alternatives, leaving no rock unturned on what the potential solutions could be. And so this is very much an ongoing process. We didn't want to come forward with a solution in our GIP that we filed earlier this year or in any other proceeding to say, hey, we've got a capacity constraint and here's a traditional pipeline solution that can solve it. That we have no concerns about the issue of that type of solution to solve it. What we're trying to do is take a much more thoughtful approach in light of the Commission's clean heat rules and gas infrastructure planning rules, which are new as of this year, to say, let's study all available options, particularly non-pipeline alternatives, being electrification and energy efficiency, being some of those foremost resources, to see if we can avoid those types of investments. And these types of alternatives could save costs, they could reduce emissions on net over the long term, and or do both. And we want to make sure that whatever long-term solution we provide is the best possible. And so we see CNG and LNG being a critical resource to help kind of bridge these processes, to address constraints in the near term while letting us study and or implement solutions to avoid those types of traditional investments over the longer term.
Thank you for your testimony today, Mr. Piquet. No further questions.
And I actually have one just follow-up question. It's related to that. And I'll confess, I don't think, done a public service rate case in a while, so I don't know the answer to this question. Mr. Piquet, does public service have one single GCA area encompassing all of its service areas within Colorado, or is it broken up into individual GCAs?
It's one area, Your Honor.
Okay. All right. So, to the extent that the commission wanted to localize these costs on the folks who are asking for this Breckenridge area, or the area served by the infrastructure where this alternative is being implemented, it doesn't sound like there'd be any simple way of doing that.
I would say there would be no simple way of doing that, but I would also look at it in the broader context, right? To say, if these investments if these costs are being incurred to serve a particular community, it's not just isolated to that community because it's one system at the end of the day. And so what happens on the Front Range affects what happens on the mountains and vice versa. Secondly, what the company is doing to invest in the Front Range, right? If we're talking about here just the GCA, to procure natural gas commodities, both on the commodity side and the upstream side, there could have been large costs incurred to serve frontline communities that these mountain communities are also paying for, right? And so it's just one system at the end of the day. So I would just bring that concept to bear when we're talking about these specific costs that were incurred up in Breckenridge. And
in addition, I think the record reflects, but you correct me if I'm wrong, public service is doing these CNG/LNG projects elsewhere on the system. Is that right?
Yes, this is the only LNG site across the company system, but there are several other sites where we are deploying CNG.
And is CNG being deployed there for similar reasons to the LNG project in Breckenridge as a bridge or temporary solution until public service can come up with an acceptable long-range solution?
Yes, they're used to address capacity needs. I won't comment as much on the temporary or permanent basis as I'm less familiar with those specific CNG deployments, but yes, it's serving a similar end. And the differences between why are we using some CNG and LNG in certain places and not others, it's really kind of site dependent and the capacity constraint needed to be served, right? Those resources have various pros and cons, and we try to match the solution to the problem.
Okay. All right. Thank you for that clarification. Thank you for your testimony. Mr. Manchel, if you have any, hopefully, if any at all, limited redirect in light of what I just asked, here's your opportunity.
Thank you for the opportunity. No questions.
Okay, thank you. So, Mr. Piquet, thank you again for your testimony. It's been helpful. And you may step down, as it were.
Thank you.
So my understanding is based on the cross-examination matrix that Mr. Skluzak is next. Do I have that right?
Yes, Your Honor.
Okay, so Mr. Wittershine, you may call your witness.
Thank you. UCA calls Mr. Corey Skluzak to the stand.
Thank you very much, and welcome, Mr. Skluzak. Good to see you again. Please raise your hand and answer the following question. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
And is there anybody there in the room with you while you're going to provide your testimony?
No.
Okay. If that changes, or if anybody attempts to communicate with you electronically or otherwise while you're giving your testimony, please let me know. Okay.
Yes.
And why don't you go ahead and state and spell your name for the record?
Corey Skluzak, Coryskluzak.
Thank you for that, Mr. Wittershine. You may proceed.
Thank you, Your Honor. Hi, Mr. Skluzak.
Hello.
Can you tell me who you represent in this proceeding?
The Office of the Utility Consumer Advocate, or UCA.
And what is your role in the office?
I'm a rate analyst, financial analyst.
You caused hearing exhibit 400 and the accompanying attachments filed today.
Yes.
Would your answers be the same in the testimony if I asked them here today?
Yes, there were a couple of minor grammatical errors, but we did not think that it rose to filing a whole revised version. So if I do have some questions on those parts, I will mention that I used improper verb or what have you.
Thank you for the clarification, Mr. Skluzak. Mr. Skluzak is available for cross-examination.
Thank you, Mr. Wittershine, and I believe Public Service is the only one that's reserved time for cross-examination. So, Mr. Mansholt, Mr. Skluzak is yours.
Good afternoon, Mr. Skluzak. Thank you for being here.
Good morning.
My questions are less from the previous discussion we had this morning. So I don't suspect we'll need the full cross time I reserved for you as a preliminary indication. I'd like to just briefly start with the Commission's clean heat plan requirements and rules, and similarly the gas infrastructure plan rules. Maybe you could just take a step back for us, and could you put in your own words your understanding of the purpose and intent of the clean heat plan?
I was not assigned to the clean heat plan, so no. My only familiarity with that is from talking to the analysts in our office who were assigned to them, and then I reflected that in my testimony.
Did you have any testimony that certain of the company's LNG or CNG plans should be addressed in the clean heat plan filing?
I believe I did mention the clean heat plan filing in my testimony.
If you don't know the purpose and intent of the clean heat plan, how can you recommend that the company should address its use of LNG and CNG resources in the clean heat plan?
Because my high level understanding is the Commission wants to look at public services overall approach to reducing greenhouse gas emissions. So from that high level basis is how I testified.
Okay, that's all I'm asking for you to do is talk about your high level understanding. I'm not asking you to address the quoted legislative intent or anything like that. So given you have a high level understanding, we'll try once again. What's your high level understanding of the clean heat plan?
I just stated it.
Okay, so it's, I think as you said in your words, to accomplish certain emissions goals?
Yes.
Okay. And what about the gas infrastructure plan? Let me be more specific. The Commission's rules implementing the gas infrastructure plan requirements. What is your general understanding of the purpose and intent of those rules?
Could I refer to my testimony?
Sure.
So in hearing exhibit 400, which is my answer testimony, starting around page 13 is when I first start mentioning the gas infrastructure planning process, GIP. I also talk about it elsewhere on page 38. Excuse me, not talk about it, I wrote about it. And I just gave my high-level understanding that the gas infrastructure planning was to look at non-pipeline alternatives to public services traditional approach to delivering gas molecules.
Okay, would you agree with me that one of the purpose and intents of the gas infrastructure plan rules is such that the company's gas plans and investments work in conjunction with the new clean heat plan emissions goals?
I'm unsure.
Okay. Can we, from box.com, pull up what's been pre-marked for identification as hearing exhibit 106? And I'll ask us to turn to page 13, please. This is just, I think I'm going to direct you to a statement of intent to try to just make this easier on all of us here a bit. But I do appreciate you providing your background understanding. In the middle of the paragraph, there's a line that starts with, as stated in the NOPR. Do you see that?
Yes.
Would you mind reading that sentence out loud?
First, may I ask a clarifying question?
Sure.
What is this document?
I'm
And
sorry.
what is the proceeding?
Sure. Let's go back to the first page. Thanks for raising that. This is decision number C220760. And the preceding number was 21R0449G. This was a rulemaking proceeding. And the title of this proceeding was about the amendments to the rules. I'm going to paraphrase here. For the gas rules to implement the gas utility planning rules and also implementing the clean heat plan rules, as well as updates for demand side management. Are you with me now?
Yes. Back in 21, there were two rulemakings. And so I wanted to make sure this wasn't the GCA rulemaking as opposed to the clean heat plan rulemaking.
Very helpful clarification. Thanks for doing that. Now, if we could just go back to that one sentence, this is on page 13, and it's paragraph 27 again, and it's a sentence starting with, as stated in the NOPR.
Yes, oops, that's helpful. Yes, I see it.
Would you mind reading it out loud?
As stated in the NOPR, the gas infrastructure planning rules are intended to work in conjunction with the clean heat plan rules during the coming years when the gas utilities will transition their businesses and the services they provide to their customers in order to achieve the substantial reductions in statewide greenhouse gas emissions required by section 25-7-102 subsection 2 subsection G CRS.
Great job with this statutory reference. So we can clarify here that one of the intents of the gas infrastructure planning rules is that they'll work in conjunction with the clean heat plan rules, correct?
According to what I just read, yes.
Thank you. I'd like now to turn to page 31. And we'll look at that paragraph 72. And I'm going to, I'll read this one. The first sentence actually in that paragraph 72, I'm going to read out loud. It says, the commission agrees with CEO that the various rule sections proposed through this proceeding are designed to, among other goals, foster an integrated and holistic approach to maintaining an affordable and reliable gas system. while at the same time reducing emissions in accordance with the state of Colorado's short-term and long-term statutory goals. Did you follow my reading there?
You had a correct reading.
I'm happy to backtrack a bit if it's helpful, but this sentence is part of the commission's discussion of the GIP rules. And my question for you is that you would agree with me that this recognizes that the GIP and the Clean Heat Plan rules attempt to work comprehensively to promote an affordable and reliable gas system that reduces emissions based on statutory goals, correct?
Well, first of all, when the commission says it agrees with CEO regarding various rule sections, I think from the caption in this proceeding was as to the clean heat rules and not the gas infrastructure planning rules, or is this a combined rulemaking for those two?
Yeah.
So I'm a little bit confused.
Yeah, sure. This was actually a quite large rulemaking, and all of those were actually involved in this decision.
So when the commission says it agrees with CEO that the various rule sections, I'm unsure if they're referring to clean heat plan rules or gas infrastructure plan rules or both. I'm unsure.
Okay, that's fine. I'll let this decision speak for itself. You agree that the commission's GIP and Clean Heat Plan rules apply to public service, correct?
Yes.
Okay, let's go back to the very, very beginning of this decision on page 1, please. The mail date here, as shown on the screen, was December 1st, 2022, correct?
Yes.
Now, considering the company's usage of third-party LNG in Breckenridge, do you recall that the company's deployment of that resource occurred for the 2022-2023 winter heating season?
Was the question, do I recall when it was deployed?
Yes.
I believe it was sometime prior to the start of the winter heating season, but I'm not sure exactly when that heating season starts for Breckenridge as opposed to the Front Range.
Okay. Would you agree that the company's use of the third-party LNG resource in Breckenridge generally coincided with the commission's issuance of its GIP and Clean Heat Plan rules?
I would say a better way to phrase that is the company's LNG deployment was deployed after this particular rulemaking started.
Okay. Do you think that the timing of the company's deployment of third-party LNG in Breckenridge was a mere coincidence with this pending rulemaking, or was a company effort an attempt to effectuate the intent of these rules?
I don't know what the company's intent was.
Do you think it was a mere coincidence of timing?
I don't know.
Okay. Let's now open hearing exhibit 102, please. And this is the rebuttal testimony of Mr. Jason Piquet. I'd like to please turn to page 13. If you could scroll down a little bit, we can stop right there. I'm going to be focusing here on lines 9 through 17. You feel free to go ahead and read this one to yourself.
Okay.
And just let me know when you're done.
Yes.
Okay. And I'm paraphrasing here, but in this section, Mr. Piquet addresses that historically gas utilities address capacity constraints with pipeline projects involving new long-lived capital assets. Is that what he's explaining?
Yes.
And prior to the commission's GIP and Clean Heat Plan rules, is it true that gas utilities addressed capacity constraints generally with long-lived capital pipeline projects?
Well, I think the key word in your question is generally. I can agree to generally, but I would think also that demand side management has also been employed to shave the peak, as it were.
I appreciate that. Now, however, with the GIP and the Clean Heat Plan rules, as we discussed here a bit earlier, gas utilities are being asked to address on a more integrated and holistic approach methods to maintain affordable and reliable gas at the same time reducing emissions, correct?
That sounds right. Are you reading from a particular decision or something?
I was referencing the statement from the decision we looked at previously where the commission was agreeing with CEO's comments.
That's helpful. I appreciate that context. And I would agree that that's what the commission wrote, subject to check.
Okay. Can we please turn the page to 14, please? And we'll look down at lines 20 through 22. And Mr. Piquet says in these lines, with the backdrop of these new filings, and here when he says new filings, my understanding is he's referring to GIP and Clean Heat Plan filings. I'll continue. The company is now more than ever exploring prudent and safe methods to avoid, defer, or mitigate more traditional gas pipeline projects. He then goes on to state in the next sentence, in support of that exploration, LNG, CNG resources have an important part to play, often as a bridge. Do you agree with these statements?
Potentially, but I don't think the proper approach to this is for the company to just simply deploy this without commission prior approval. And in fact, they should be folded in to these other proceedings so that the commission can highlight and discern exactly what's going on and whether this is the most cost-effective bridge versus other options.
Okay, I don't think he's referring to any regulatory processes here. I think he's just talking about kind of the part LNG, CNG resources have a important part to play, specifically as a bridge. And I'm wondering, do you at least agree with that? Regulatory processes notwithstanding.
Well, I mean, Mr. Mansfield, I would respectfully disagree. He starts this sentence with the backdrop of these new filings, which infers regulatory processes.
Do you agree that LNG and CNG resources have an important part to play as a bridge to potentially avoid, defer, or mitigate more traditional gas pipeline projects?
It depends upon the facts and circumstances. It very well may be that a robust energy conservation messaging system may shave the peak and avoid that design day in a 30-year span that the LNG rollout in Breckenridge was utilized for.
Does the UCA not want to see public service deploy LNG or CNG third-party resources?
It depends upon the facts and circumstances, and if there are more affordable alternatives available.
Okay. That's helpful. Can we please turn to page 15? Oh, we're already there. Sorry. I think we're actually going to go up on this page. Oh, actually, no, I'm sorry. It's page 15. So it is going down. And we're going to look at lines 9 through 11. Here, Mr. Piquet says, state another way, without the use of LNG, CNG, the company would have an increased need for pipeline projects and associated emissions impacts from potentially higher throughput. Now I'm going to ask you a similar question here. Do you conceptually agree that without the use of LNG and CNG resources, the company would have an increased need for pipeline projects?
Not necessarily. And if you go to the second sentence, I think Mr. Piquet actually makes the case that LNG and CNG deployment should be included in PSCo's gas infrastructure plan and clean heat plan.
I'm not sure where you're going with that. We weren't really talking about inclusion of these resources in a clean heat plan or a GIP filing.
Well, if you look at the sentence starting on line 11, finishing up on 14, the way that I read that, interpret it, is Mr. Piquet actually makes a good case that LNG and CNG deployment should be included in those two plans.
Okay. So I think you're changing topics on me here a bit, but let's go there. So you're saying now that you can't really comment on whether LNG or CNG, without the use of those resources, there'd be an increased need for pipeline projects. Instead, all you can say is that use of LNG and CNG needs to be addressed, including plan and GIP filings. Is that right?
No, you mischaracterized my testimony.
Well, why don't you try to?
In answer to your question, I said not necessarily. And then I switched to the second sentence where Mr. Piquet actually creates a basis for why CNG and LNG should not be deployed without commission approval, but should be included in these two plans.
Okay, let me ask you, attempt again here. Do you agree that without the use of LNG or CNG, there could be an increased need for pipeline projects?
There's a potential for that.
Okay, thank you. Do you, and this, maybe this is about the second sentence that you've been focusing in on here. Would you agree that use of LNG and CNG resources may facilitate non-pipeline alternatives that may lead to solutions that avoid new pipeline projects?
May facilitate. Could I ask you to define what you mean by that?
Well, this goes back to us discussing Mr. Piquet's testimony that LNG and CNG resources may act as a bridge to study or implementation of non-pipeline alternatives.
Thank you for that clarification. Yes, there's the potential for that, but I would also say the deployment of LNG, for example, is in and of itself a non-pipeline alternative, albeit temporary.
If I understand your testimony, then you're saying it could be both. It could both facilitate or in of itself be a non-pipeline alternative. Is that correct?
Yes.
Okay.
And I think I discussed that somewhere in my my answer testimony about the non-pipeline alternatives.
Okay. Well, we can refer the record back to there. Next question here. what's more consistent with the clean heat plan? Developing a new capacity pipeline project or using third-party LNG or CNG resources to mitigate the need for a new capacity pipeline project?
I don't know.
Okay. Let's go back to box.com. And, I'm sorry, before we go there, I'd actually like to open up Mr. Skluzak's answer testimony, hearing exhibit 400. And we'll go to page 13, please. Pardon me. And can you scroll down just a little bit? Stop right there. Thank you. Looking at lines 9 through 13. Actually, 9 through 11. You conclude in this sentence here that the commission's GIP process is the correct proceeding to discuss, analyze, and compare the use of LNG and CNG resources, correct?
Yes.
And then in the next sentence, you go on to state, actually, it's the last sentence in this paragraph. You go on, it's lines 11 through 13. You go on to state that the ALJ can deny the company's advice letter accordingly and allow public service to take up use of LNG and CNG resources in the ongoing GIP. Is that correct?
Yes.
Okay. Do you know if the UCA raised any issues related to LNG or CNG in its sets of comments in the GIP proceeding?
I do not know.
Okay. Let's go see. Let's go to box.com, please. And from there, I've got a document pre-marked for identification as hearing exhibit 103. Actually, yep, that's it. And this is what's labeled as the initial comments of the Office of the Utility Consumer Advocate. And this proceeding number is 23M-0234E. And the purpose of this docket is the company's GIP proceeding. And you can scroll down to the very end of this just to show this is a complete version of the UCA's comments. And now I'll just go back to the table of contents towards the beginning. Oh, I don't think there's table of contents. That's okay. My understanding here is that you're not familiar with these comments. Is that correct, Mr. Skluzak?
That's correct.
Okay. Well, rather than make you look through them, then I'd just like to add them to the record. So this would be hearing exhibit 103. And I think the administrative law judge can take administrative notice of these comments filed in another proceeding.
Any objection, Mr. Wittershan?
No objection.
Admitted by administrative notice. Hearing exhibit 103. Go ahead.
I'm just going to do this 2 more quick times for everyone's advance notice here. The next document is hearing exhibit 104. And as stated here, this is the same docket, but now we're dealing with the UCA's reply comments in this public service GIP filing. Again, you're not familiar with these comments, correct?
That's correct, but I would note for the record, the previous document was 23M-0234E, and this is 23M-0234G.
Potentially the UCA had an error in its comments.
Okay.
If that's the case. Um,
Well, should we go back? Let's just go back to
Sure.
103 and take a look at so the title. Yeah, I think it's fair to say that the reference is 23M-0234E in hearing exhibit 103 is incorrect. It
Yeah,
should be 23M-0234G, I
if it's
believe.
helpful, we can scroll down to the introductory paragraphs.
Yeah, okay.
This is about the clean heat plan here and the creation of the GIP rules. I'll let them stand for themselves. If you think they stand for something else, you can certainly get to it at the legal briefing stage.
Yeah, so I mean, I think my statement is correct. Anybody, Mr. Wiederschein, Mr. Skluzak, you can correct me if I'm wrong. If you need more time, you can correct me in SOPs, statements of position. But why don't we go ahead with hearing exhibit 104, which is where I think you were,
Yes.
Mr.
Thank you,
Mansholt.
Yeah, given you're not familiar with these, again, I'm just going to ask your honor to take administrative notice of these reply comments in the public services ongoing GIP proceeding.
Any objection, Mr. Wiederschein?
No objection.
Okay, so hearing exhibit 104 is admitted by administrative notice.
Okay, last one. And this is box.com pre-marked as hearing exhibit 105. And these are denoted as the final comments of the UCA in that same GIP proceeding. And I would, these is the full comments. Feel free to scroll to the very end just to help Mr. Wittersheim get up to speed a little bit. But I had asked your honor to also take administrative notice of this final comment pleading in the GIP from the UCA.
Any objection, Mr. Wiederschein?
No objection.
Okay, hearing exhibit 105 is admitted by administrative notice.
Thank you very much for your time, Mr. Skluzak. Have a wonderful day. No further questions.
Welcome.
Thank you, Mr. Mansholt. And Mr. Skluzak, thank you for your testimony. I don't have any questions, so I'm going to turn it over to Mr. Wiederschein to see if he has any redirect directed to the cross done by Mr. Mansholt.
I have no redirected questions, Your Honor. Thank you.
Okay. So thank you for that, Mr. Wiederschein, and thank you again, Mr. Skluzak. Your testimony has been helpful. Very much appreciated. You may step down.
Thank you.
So we have one witness left. Let me just ask everybody. We can continue on now. We could take a brief break, given what the cross-examination matrix says. I don't think we should take a full lunch break, but let me just ask, particularly Ms. Wiesenthal and Ms. Kunkel, but anybody else, does anybody want or need to take a limited, 5 to 15-minute break?
I'm fine, Judge.
Okay.
Whatever you guys want to do is fine with me.
Okay,
Maybe take a 10-minute break.
Okay. All right. Why don't we go ahead? It's noon now. Let's be in recess until 12:10. All right. Thank you.
Thank you.
Okay, Ms. Wiesenthal and Ms. Kunkel, are you ready to go?
Ready, Judge.
Ready? Thank you.
Great, thank you. And Mr. Santisi, are you ready to go and your witness?
Yes, we both are. Thank you, Your Honor.
Great. So we are back on the record in proceeding number 23AL-0325G. We're ready to move on to the next witness, which I understand is Ms. McGee. So Mr. Santisi, you can call your witness.
Okay, staff would like to call Ms. Bridget McGee.
Great, thank you very much. And welcome, McGee. It's good to see you.
Hello, Mr. Farley.
And please raise your hand and answer the following question. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Great, thank you very much. Please state and spell your name for the record.
Bridget McGee, BRIDGET, MC, capital GEE.
Great, thank you very much. And Mr. Santisi, you may proceed.
Okay, great. Thank you. If you could please tell us your employer and your responsibilities as it relates to this proceeding.
I work for the Colorado Public Utilities Commission, and I'm a rate financial analyst assigned to this case.
Okay. Hearing Exhibit 300 is your answer testimony admitted into the evidentiary record. Is that correct?
Yes.
Ms. McGee is available for cross-examination.
Great, thank you, Mr. Santisi. And as I understand it, UCA is the only one with questions for Ms. McGee. So, Mr. Wittershine, the floor is yours.
Thank you, Your Honor. Hello, Ms. McGee. My name is Patrick Wittershine.
Hello.
I'm representing the Utility Consumer Advocate. It's nice to meet you. Ms. Kunkel, could we please pull up hearing exhibit 300? Ms. McGee's testimony. Thank you. And scroll to page number 3. Thank you. So, Ms. McGee, you testified that staff recommends the commission define what costs may be recovered through the GCA, and based on this, the commission then decide to either approve or disallow PSCO proposed changes to its tariff. Is that correct?
Yes.
And you also testified that staff's opinion is that only commodity costs are recoverable through the GCA. Is that right?
Commodity and upstream, I believe.
Okay. So, in your testimony on page 3, starting at line 11, when you testify, staff recommends commodity gas costs, including the cost of natural gas, LNG, CNG, and upstream costs are recoverable through the GCA. The upstream costs you're referring to here are strictly upstream commodity costs. Is that right?
That is correct.
Okay. And in your view, the upstream costs can be separated into upstream commodity costs and upstream non-commodity costs.
Well, yes. I guess you could characterize it that way.
So the upstream commodity costs are appropriate for GCA recovery, correct?
Yes.
And upstream non-commodity costs are inappropriate for GCA recovery?
Yes.
So for the LNG and CNG non-commodity upstream costs that are inappropriate for GCA recovery, how should the company recover those costs?
Objection, Your Honor. This is friendly cross. The UCA shares that same position. I'm sorry, yeah, the UCA shares the same position on staff that those are not recoverable or inappropriate here.
Okay, I'm going to overrule and allow the testimony. So go ahead, Ms. McGee.
Yes, I believe they should be in base rates. And the more I listen to as I listened to Mr. Piquet's testimony this morning, his use of terms really made me think base rates. I think he said they're exploring and researching and this is ongoing. I think for those reasons, it definitely should be in base rates.
Thank you, Ms. McGee. No further questions, Your Honor.
Okay. And I don't have any questions for Ms. McGee either. So with that, Ms. McGee, let me thank you for your testimony. Appreciate it very much, and you may step down.
Thank you.
Or
And
actually,
Your Honor, I just
Mr.
wanted to clarify for the record, the staff does not have any redirect, so thank you.
Thank you. And I apologize, Mr. Santisi. I just skipped right over top of that, so thank you for the clarification. Ms. McGee, again, thank you. And now you may step down. So, I think we're at the end of the hearing here, and I'm about to close the evidentiary record. But before I do that, I wanted to see if anybody wants to at least attempt to get something else into the evidentiary record. Not hearing anything from anybody, so I'm going to go ahead and close the evidentiary record. Statements of position, I believe, are due on January 5th, 2024. Do I have that right? Anybody disagree?
I believe it's the 8th, Your Honor.
Is it?
Maybe
Give me
wrong.
just a moment.
I have in my notes the 8th.
Give me just a moment. So what I'm reading is in my decision, R23-0596-I, the one that issued on September 11th. And that's the one that vacated and reset the hearing, I believe, to today. And I believe what was asked for, and maybe I got this wrong, but what was asked for was an extension until January 5th for the statements of position. In any event, that's what's stated in that decision, R23-0596-I. Does that still work for everybody? Let's see.
Thank you for that re-clarification, Your Honor. It's my oversight. That does refresh my recollection, and that's agreeable to the company.
Okay. Great. So not hearing anything from anybody else, January 5th, 2024 is the deadline for statements of position. Is there anything that anybody would like me to address before we adjourn today? Okay, not hearing anything. Let me thank all of you for putting on a good hearing today with good testimony and good questions. It's been helpful to me, so I want to thank you for that. I don't think I'll see any of you before Thanksgiving, so I wish you all a happy Thanksgiving, and I wish you all happy holidays as well. So with that, we are adjourned. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.